Good morning. Morning, everyone. Is the voice okay today? Can you all hear me clearly? Is the voice fine today? We've sorted it out. Yes? Good morning. Good morning. Good morning. Absolutely clear. Okay, good. We will start from where we left off yesterday. We are going to now discuss religion and secularism related rights. Now, before we get into Article 25 to 28, which primarily deal with religion, let's quickly understand how does secularism work on a larger concept. We've discussed this broadly in the context of the preamble. When we look at secularism, we look at secularism from 2 points of view. One, from an individual's perspective, and two, from the perspective of the country or the state as a whole. Remember, this is state with a capital S and not a small s. Now, when we talk about secularism from an individual's point of view, there are largely three kinds or three types of people with their relationship with God. Now, you must understand that the word religion actually comes from a Latin word religare, Religare. This is the Latin word from where religion comes from. Now, for those of you who may not remember, what Sanskrit is to Hindi is what Latin is to English. Okay? So, back in the olden days when English was not developed as a language, Latin was used as your primary form of communication. So the word religion that comes from the Latin word religare, which basically means association for common good. So the original purpose of religion was to essentially get people together, have a common association for certain common principles of goodness of society. Now, when we look at it from an individual's perspective, there are basically three kinds of people. Now, you would also understand that the study of religion is called theology, right? The study of religion is called theology. On the basis of this word theo, will almost everything else be defined. So, there are three kinds of people. First are theists, second are agnostics, and third are atheists. As you would clearly remember, theists are people who believe in God. Agnostics are people who themselves don't believe in God, but also don't have a problem if you believe in God. They believe in something called coexistence with the believers and the non believers. Whereas atheists is an aggressive form, it's an extreme form. If theists are people who believe in God, atheists are people who don't believe in God and have a problem if you believe in God. They believe that religion or man or God is the root cause of all evil in the country. Now, most people in India would either be theists or would be atheists. We will find very little space for agnostics to exist in the country. Okay, so this is the larger understanding on the basis of individuals. Now, when we look at it from the state's perspective, the government's perspective, the country's perspective. Now, there are basically two kinds of countries in the world. One is a theocratic state, and the second is what is called a secular state. Okay, second is called a secular state. The basic difference between a theocratic state and a secular state is that in a secular state and in a theocratic state, the religion is above the law, whereas in secular states, the law is above the religion. The basic difference here is that in a theocratic state, whatever laws the government, the president, the parliament, the ministries, or anybody makes, those laws will always be in conformity with a specific set of religious principles in that state. Usually, theocratic states are going to have a singular preferential religion. A singular preferential religion, which means one religion will be above all other religions, and no matter what law you make, that law cannot violate the principles of religion which are devised from time to time. Whereas secularism is the exact opposite, wherein if there is a religious conflict with morality, all religious issues, whether they are right or wrong, whether they are moral or immoral, can be overridden by the law. So, you will often see morality on the side of law as opposed to religion. What will happen in a secular state is, for example, there is a religious practice which is objectionable. They will use the power of the law to stop that religious practice. But in a theocratic state, if there is a religious practice which is immoral, the law cannot be made to override the religious practice. That's the basic difference. मतलब सीधी सिंपल बात यह है कि थियोक्रेटिक कंट्रीज में चाहे धर्म में कितनी भी दिक्कत हो, कानून धर्म को ओवररूल नहीं कर सकता. सेक्युलर स्टेट्स में जहां धर्म में कोई भी इशू होगा, वो लॉ से उस धर्म को कॉम्बैट कर देंगे, उसको रिमूव कर देंगे. Right? Now there are essentially two kinds of secular states in the world. You're either a passive secular state or you are an active secular state. The basic difference between passive and active is that in passive, the government plays a minimalistic role in religion, a minimalistic role, which means that they will only use law to remove objectionable religious practices. This is also called an interventionist approach. कि अगर रिलीजन में लिखा है ह्यूमन सैक्रिफाइस, तो वो कानून बना देंगे ह्यूमन सैक्रिफाइस इलीगल है, बस उतना ही होता है. बट इन एक्टिव सेक्युलरिज्म, not only are you minimalistic, but you are also welfare oriented. You will promote all religions equally, provide for all religions in as many places as possible. Okay, now that is the fundamental difference. For example, a lot of your Middle Eastern countries are actually theocratic states with their official religion as Islam. Okay, for example, France, and this was a question which was asked in UPSC in 2019, if I am not wrong, is a passive secular state. And our very own India is an active secular state. ये बहुत बेसिक फर्क है. I'll give you some proper interpretations of this, some examples of this. जैसे for example, in the Middle East, especially in the Arab Emirates, no citizen can be taxed, because Islam में tax करना हराम होता है. So you cannot tax anybody if you're in an Islamic country. But in Islam, you have something called zakat. Zakat means that every individual, as per their own capacity, as per their own capability, can contribute a proportion of their income for a social cause. उसको zakat कहते हैं. तो zakat allowed है, लेकिन taxes नहीं. But today, because of the economic issues in the Middle East, even in places like Dubai, they have started some form of taxation, some form of golden visa rules. All right. So that is the basic explanation of what is a theocratic state. अब आप सेक्युलरिज्म में देखिए, the same will apply here, but in a passive form. Up, for example, in India or in France for that matter, you would remember France is a passive secular country. You would remember a few years ago, the country of France had what it had done, what it had banned the burqa. Now you must understand, firstly, burqa is an incorrect term. There are two words. There is one is called burqa, the other is called hijab, right? Burqa is the entire outfit. Hijab is what you only wear to cover your face. So they had banned the burqa, saying it is a national security concern. It could be misused by people, and this is a passive approach. But if you look at India, this is where it gets very interesting. For example, in India, human sacrifice, animal sacrifice in the name of religion is banned. So we are also minimalist in our approach. At the same time, you would remember when Air India was the government of India, we had subsidized Air India flights. We had subsidized Air India flights for Hajj, for the pilgrimages, for during those times of the year. That is India. In the same way, the government provides for security arrangements during the Badrinath and the Amarnath Yatra. Some of the most important religious shrines in the country, the Shirdi Trust, the Tirupati Trust, they're all managed and administered by the government. In fact, there is a movement in the southern part of the country. That movement is called Free the Temples movement, wherein these temple priests are saying that we should be the ones completely running the administration of our temples. The government has no business doing so. So whether it is the Vaishno Devi Trust, the Tirupati Trust, or even, for example, if it is the Shirdi Trust, all of these are actually managed and administered by the administration of the state. You have civil services officers who are the chief trustees of those trusts. That is an active approach. That the government is involved in the promotion of all religious activities. Okay, so this is broadly how it works. Now that we understand how broadly it works, let us see from Articles 25 to 28 in the Constitution of India, how are we dealing with the notions of secularism. The larger title of Articles 25 to 28 is freedom of religion. The larger titles to 25 to 28 is basically freedom of religion. Now see how this works. It is called the right to freedom of religion. Now, Article 25 and 26 are specific rights for people, and 27 and 28 are institutional rights for religious activity. Okay? So, what does this article say? The title is Freedom of Conscience and Free Profession, Practice and Propagation of Religion. I'm going to come to that when we look at Article 25, Clause 1. Now, it says, subject to public order, morality, and health, and now comes the most important part, and other provisions of this part. Now, you see, there is something very interesting to note here. Article 25 is the only fundamental right which starts on a negative note. If you compare it to Article 19, which is your freedom of speech and expression, freedom of speech and expression says all citizens have the right to freedom of speech and expression. Then in Article 19, Clause 2, they say your freedom is restricted to so and so, so and so, so and so. But in religion, you start your right with a restriction, which means the makers of the constitution were absolutely clear, were absolutely okay, and they absolutely understood that religion is going to be a secondary or a subordinate right as far as India is concerned. It is never going to be an equated fundamental right. So that's the first understanding. The second understanding is subject to other provisions of this part. What is this part? This is part 3. Part 3 includes fundamental rights, which means all fundamental rights are equal, but the right to religion is a secondary fundamental right. So restrictions of all other fundamental rights will also be applied to religion. So religion becomes a very secondary or a very a subordinate position of fundamental rights in the Indian Constitution. It is very clear that not only public order, morality and health, but also provisions of this part, which means tomorrow if there is a conflict between 21 and 25 and Article 21 is the right to life and liberty, then Article 21 will be superior to Article 25 because it is a subordinate right. Religion is a subordinate right. बेसिकली मतलब ये है कि आपको धर्म की आजादी तो है, लेकिन वो धर्म की आजादी बाकी सब राइट से भी सेकेंडरी है. वो बहुत क्लियरली कॉन्स्टिट्यूशन में लिख दिया था. ठीक है. नाउ अंडर आर्टिकल 25 देन इट सेज subject to public order, morality, health and other provisions. You will see the word morality here. The word morality in the constitution is only in 2 places. One in article 19 and the second in article 25. This becomes important because this was the first question in this year's mains exam. All persons. All person means it is applicable to both citizens and foreigners. All persons are equally entitled, now understand this, to freedom of conscience. This is the first part. Then the right to freely profess, practice and propagate religion. So what they've done is they've kept conscience as one part and then the right to freely profess, practice and propagate religion. Now each of these 4 words mean 4 completely different things. Okay? Each of these 4 words mean 4 completely different things. So what are the key terms that are mentioned in Article 25 clause 1? First, the freedom of conscience. Then the freedom to profess. Then the freedom to practice, and now the most controversial, 4th, the freedom to propagate. Now you would remember I categorically told you that the UPSC is never going to ask a specific religion based question. And the reason UPSC is not going to ask a specific religion based question is because if you ask a candidate their opinion on a specific religious based issue, then you are discriminating against the candidate on the basis of religion, because an answer would be on the bias and the examiner would also give you marks on the basis of the religious bias of the examiner. So the kind of questions that are usually asked are very generic in nature or issues that affect all religions per se. Now, so what are the basic 4 terms? The first term that we talk about, the first term that we refer to is basically conscience. Now conscience means, in ethics, in moral philosophy, conscience is often defined as the voice of God, which means if you look at core moral philosophy, it means that if you have a conscience, then there must be a God. That is not necessarily true. Your conscience may exist whether or not God exists, right? But legally, in modern day practice, what does the word conscience mean? The word conscience here means that you have the choice of religion. Your relationship with God or your relationship with anything supernatural or a higher existence is an extremely personal relationship. Whether you want to have one with God or not, how you want to have it with God, whether you want to have it at all points of time or not, do you want to be religious or not, it is entirely up to you. You have the freedom of conscience. However, in reality, there are certain things in India which makes the freedom of conscience a slightly compromised affair. For example, firstly, there is an issue of gender, and secondly, there is an issue of documentation. Now, if it is an inter-religion marriage, then the child will most necessarily have the religion of the father, unless very specifically said the child is not going to. Okay, child is going to very specifically inherit the religion of the father, unless very specifically it has been said that the child is not. Okay, second, in a lot of government documents, you may remember filling 10th and 12th board forms. You may remember school diaries. You may remember in the school diaries that we were maintaining, or the 10th and 12th board forms, or even UPSC forms, you are asked to disclose your religion. Now, the question is, what if you are not religious? If you are not religious, then why are you being asked to disclose your religion? So, in modern day practice, in contemporary practice, the freedom of conscience in India is a slightly compromised affair, because religion also has a role to play in property, in marriage, in adoption, and inheritance. We're going to come to that later. Okay? The word profess here means identification of religion or the confession of religion. A higher form of profess is practice. So, profess includes mostly what are called religious symbols. Whether people who follow Islam wear a skull cap, or Christians wear a crucifix, or Hindus wear a Rudraksh mala, or people who follow the Jain religion sometimes will wear a white piece of cloth. These are religious symbols. You are absolutely allowed to identify yourself, carry it. I'll give you a very interesting example. In the religion of Sikhism, there is a very small community who, after, as per religious practices, if that community has tasted what is called Amrit, then they are legally allowed to carry a very small weapon called a kripan with them. You would have seen a lot of Sikhs they carry a dagger like small pointed weapon with them. And they're legally allowed to, because it is an identification of their religion. They can even board a flight with carrying that dagger with them. No other country you can. If they had to travel internationally, then the authorities of that country can ask them to take off their daggers. But in India, you can travel in an aircraft with a knife with you if you are somebody who has tasted quote unquote Amrit in the Sikh religion. Alright? Apart from this, you can also understand by saying that people of the Sikh religion wear turbans. They are also able to, carry a lot of those essential practices as well. So that is something that is taken care of. So profess here is identification and symbols. You have the absolute right to identify yourself, disclose to people what kind of religion you follow, and if there are any symbols that you need to, you are more than free to do so. There's absolutely no problem. Now comes the practice of religion. Practice of religion includes all ritualistic scenarios, all ritualistic ceremonies that are needed. Now, of course, this will always be slightly compromised. There will always be a lot of question marks on it. So, any practice which is not violating public order, morality, or health, that is okay. Anything else which is not, they will always be questioned. Now, with practice, the Supreme Court has devised what is called essential religious practices. The doctrine of essential religious practices. This doctrine of essential religious practices means that if a ritual is questioned, then you have to answer a very simple question. If I take the ritual away, does it make a person any less religious? Is it a fundamental component of that religion? If it is not, then in that scenario, we can remove that practice. I'll give you several examples of this. For example, you would have all heard of the word triple talaq. Now, the actual word is talaq-e-biddat. The actual word is talaq-e-biddat. Okay, talaq-e-biddat is the actual word for triple talaq. Now, talaq-e-biddat, or it is popularly called instantaneous talaq or instant talaq, right? Where a person over a period says the word talaq 3 times, and that leads to the divorce of the person from the spouse. Now, there were fundamental problems with triple talaq or talaq-e-biddat or instantaneous talaq. First, it could only be given by the men to the women. That was a fundamental issue. Two, the practice of triple talaq was that you get to say it 3 times so that you can think about it 3 times. What people used to do is send 3 WhatsApp message, talaq, 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 and it is done. Or people used to send letters one after the other saying talaq, 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 and it was done. The practice of talaq-e-biddat was basically that over say 1 year you have thought about it and you know it is not working out, so you want to get a divorce. That was the idea of it. But the practice was essentially abusing the original idea of triple talaq, right? The Supreme Court very recently in the Shaira Bano case. Now remember, Shah Bano was a completely different case. This is Shaira Bano. So in the Shaira Bano case, the Supreme Court declared talaq-e-biddat is unconstitutional, which means if any Muslim couple is getting divorced on the basis of talaq-e-biddat, it will not be recognized as a valid divorce. And the Supreme Court then directed the Parliament to make a law criminalizing triple talaq. So if anybody authorizes triple talaq, the local Maulvi does, or if the man uses triple talaq, then the person can be sent to jail. So the criminal law was made by the Parliament, and talaq-e-biddat was declared unconstitutional by the Supreme Court. Talaq-e-biddat was declared unconstitutional by the Supreme Court. Okay, that is something you must understand as clearly as possible. Okay, simple as that. Now, once we are clear with this, once we understand what it is that we are talking about, you must understand that they had applied the essential religious practice principle. The Supreme Court said, if I take triple talaq away from Islam, will a person become any less Islamic? Will a person become any less closer to God? The answer was a no. This was a very close judgment where just I think 3 judges said yes and 2 judges said no. So it was a very close call of a judgment, and still triple talaq has been declared as unconstitutional. And the principles of constitutional morality were also applied to triple talaq. Okay, so this is one. I'll give you one example from each religion, right? So this is talaq-e-biddat. From the Hindu religion, most recently, the issue of Sabri Mala. Now, nobody in the exam is going to ask your opinion on Sabri Mala, but you just need to write about Sabri Mala in 2 lines in your answers to explain the larger issue of essential religious practices. So basically what happened in Sabri Mala was that women of the reproductive age were not allowed to enter the Sabri Mala temple because the god was a bachelor. So to respect the brahmachari status of the god, and the local law allowed you to do so. The Supreme Court held that law to be unconstitutional and permitted the entry of women into Sabri Mala, saying that it is okay. The Supreme Court raised the same issue, that if you are not allowing women to enter the Sabri Mala temple, in such a scenario, if you are not allowing women to enter the Sabri Mala temple, are you making sure that you are the best version of the Hindu possible? Or if I allow women to enter Sabri Mala temple, will you become any less of a Hindu? The answer was obviously no. The Supreme Court allowed it. In Jainism, there is a practice called Santhar, which we write as Santhara, but Santhar. So Santhar is usually the elder community in Jain who believe that we have accomplished everything, we have lived a full life, and we would now want to fast unto death. Now, this is a problem in India because attempt to suicide was illegal because of section 309 of the IPC. And this was also, there were several cases of this being misused because a lot of times children used to force their parents into committing santhar so that they could acquire their property. This is currently pending in the courts of law. So in the next 2 years or so, we will probably hear of a Supreme Court judgment. We would probably hear of a Supreme Court judgment which says that santhar is illegal. Now you must understand this because this is in the larger context of suicide. So in India, what has now happened is that attempt to suicide is no longer illegal if it is done on a personal level. But if somebody is abetting you to commit suicide, is forcing you to commit suicide, then that part is illegal. So santhara. Similarly, in Orthodox Christianity, in Catholic Christianity, abortion is illegal because it is considered a sin against God. In India, abortion is perfectly legal, but within a specific set of regulations. Religion has no role to play in our abortion laws. So when we look at abortion and Christianity, okay, so these are some things that are often true of almost all religions. Similarly, in the faith of Judaism, there is a very small sect in Judaism who believes that the entry of foreign blood in the body will corrupt the soul. So what they usually do is they wear a bracelet or a ring or a necklace saying that they belong to that sect. So if that person has reached a hospital, the doctor has to first check for that bracelet. And if the person is wearing that bracelet, then no blood, no operation, nothing can be performed on that person. You would have heard of the Jehovah's Witnesses, essentially that. So they are not allowed. In India, this is not allowed. This is not legally recognized. In the West, it is. In India, it is not. All right. So there are several examples of religious practices which have largely dealt with the practice of religion. Now, to propagate religion, this is largely to do with the most common usage of this is the conversion of people. Now, if a person wants to convert on their own, that's perfectly okay, no problem. But any amount of forceful conversion, any amount of conversion with any, say, benefit in mind, there will always be objectionable. There is a law. That law was recently amended in 2021 also, where we've said that it is criminal as far as conversion is concerned. And this has always been used as a tactic. For example, there have been several reports, I don't know if they're true or not, of Christian emissaries converting lower caste Dalits into Christianity by promising them jobs, some ration amenities, equal status, and so on and so forth. So, of course, anti-conversion is very strictly looked at as far as the Indian law is concerned. As far as you know these things, this is more than enough. You don't have to get into the technical details of it. Nobody is going to ever ask you this in the exam. So these are some of the basic terms which are mentioned in Article 25, Clause 1. And they should be able to answer most of your questions. Now, We move to quickly on reading Article 25, Clause 2. I've sort of given you hints around it as well. Okay, so let's understand what they are. Article 25, Clause 2. Let me just bring 25 to properly. There you go. Okay. So, nothing in this article shall affect the operation of any existing law, the operation of any existing law, or prevent the state from making any law. These are nothing but what are called your reasonable restrictions to religion. Reasonable restrictions to religion. So, what are they? First, you can make a law, or a law on this will continue to operate, regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. Which means the government can make a law restricting any religious practice with respect to its economic, financial, political, or any other activity. So, for example, Sadhguru, or your Art of Living People, or Ramdev, or your Christian emissaries, anything that they do, the government can very easily regulate. Now, providing for social welfare and reform, or throwing open of Hindu religious institutions of a public character to all classes and sections to Hindus. Now, you must understand, Article 25, Clause B is a very interesting article. It says that the government, if they want to, and this is the constitution, they can make any law for social welfare and any law for reform and Hindu religious institutions. By the way, this includes Jainism, this includes Buddhism, and this includes Sikhism as well. Okay, so and why do we often say the problem is, if you tell somebody that you're a Buddhist or a Jain, the first thing they will tell you is you're basically a Hindu. Where does that mentality come from? That mentality comes from Article 25B of the Constitution, where in the Constitution itself, it is clearly mentioned that Hindus will include Sikh, Jain, and Buddhist. So this is from where you make all your other laws. So, for example, when we say that, the Hindu Marriage Act applies to Jains, Buddhists, and Sikhs also, it is because of Article 25, Clause B. This is the origin of it. That is why people in our country equate Jain, Buddhist, Sikh, and Hindu under the same umbrella. But it's a very interesting article because it says any Hindu religious institution of a public character to all classes and sections of Hindus. Now, most people will find there an objection to be here. Actually, there is no objection. The problem here is that you are linking religion with caste. You must understand this clearly. You are linking religion with caste. Okay. Now, there is a reason behind this. It's because, and the religion and the reason behind this is because when we look at, or we understand the concept of caste in India, right? Now we've discussed this in reservation. We understand it comprises of SC, ST, OBC. These are primarily caste-based divisions, and nowadays you have other forms of reservation such as economically weaker sections. Now you must understand, SC and ST is not applicable to Muslims and is also not applicable to Christians. It is only and only the Hindu community, and this includes Hindus, includes Jains, includes Buddhists, and includes Sikhs. Why? Because the origin of caste is Hinduism. The ancient methodology of caste is that caste originates from the caricature of Brahma, where the Brahmins come from the mind or the head of Brahma, the Kshatriyas come from the shoulders of Brahma, the Vaishyas, the business class, come from the thigh of Brahma, the Shudras come from the feet of Brahma, and the untouchables even beyond that. That is the origin of casteism. This is why SC and ST communities are only for the Hindu religions. And this is where often lower castes were not allowed to enter temples. So that is why you wrote Article 25B saying that no lower castes and everybody can access any temple as and when needed. So this is a very specific provision linking religion to caste. OBC community, you will see a lot of Muslims, a lot of Christians, all of those things. But SC, ST, you'll only see these parameters. Okay? So this is why. And there is actually a very nice pictorial representation of it. I'll show it to you so you'll understand what I'm talking about. All you have to do is type Brahma caste. See, the head, the shoulders, and then of course the thighs. I'm trying to get a better image. See, Brahmins, Kshatras, Vaishyas, Shudras, and Dalits. The head, the shoulder, the thighs, the feet, and even beyond the feet. And this is not me saying it, this is a BBC article which is talking about it. See. The origins of caste. See. So, Brahmins, Kshatriyas, Vaishyas, Shudras, and Dalits. This is where caste system originates. It's an Indian innovation, an unfortunate innovation, but an Indian innovation. Okay, this is the origin of it. If you want, you can read this article also later. It tells you about Manusmriti and the origin of it in the ancient text and stuff. How does it work? It is largely occupation based and so on and so forth. So you can go through it whenever you want to and you have the time to. Okay, all right. So this is what Article 25B is. Now, as I was telling you, the Kripans and everything are included. It has been explicitly mentioned in the Constitution in Explanation 1 and Explanation 2. So this is Article 25. Now we'll move to Article 26. This is where your Ramdev and everybody else comes in. Okay, so let's understand this. We're not going to talk about religious institutions. So the freedom to manage religious affairs, extremely relevant as far as the exam is concerned. Subject to public order, morality and health, every religious domination or any section thereof shall have the right to. Every religion will have a certain right, subject to public health, morality and health. We've covered this before. So now, what are your basic rights? To establish and maintain institutions for religious and charitable purposes. So you will often see a lot of charitable religious hospitals. You will see charitable religious schools. All of that is because you're allowed to have it under the Constitution. Then you will see manage your own affairs in the matters of religion. That is why you will hear of something called Hindu Mahasabha or the Waqf Board or the All India Muslim Personal Law Board. All of them exist because you have the right to maintain and manage your own internal affairs. Okay? All right. Yes, Vaibhav. Yes. Third, to own and acquire movable and immovable property. These are institutions. These institutions are usually recognized or registered as a trust or a society. And a trust and a society can acquire property, so they can acquire property. And you have the right to administer these properties in accordance with the law. That's okay. This is a general article. There are a lot of understandings into this. There are a lot of discussions into this, but you don't have to worry about it because they're not going to be asked in the exam. Let's look at the fun part. Article 27. Article 27 says you do not have to pay taxes if you are running a religious institution. And it is clearly mentioned in the constitution. In fact, India is one of those rare, unique constitutions in the world where it is specifically mentioned in a fundamental right that religious institutions are tax free. So, no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in the payment of expenses for the promotion or the maintenance of any religion or religious domination. So what does this mean? This basically means something very simple. It means, and please understand this, whatever Ramdev and Sadhguru do are tax free. But whatever Patanjali does is not tax free. Because Patanjali is a registered private limited company. It may have Ramdev as one of its core investors or founders or owners, but it is a company. Patanjali pays taxes. Nirmal Baba, Ramdev, Sadhguru, Sri Ravi Shankar, all of these guys, none of them pay any tax for anything that they do, for any contribution that they get, for any activity that they do. They run completely tax-free ecosystems. Okay? Again, too controversial to be asked in the exam, so don't worry about it. Now, let's come to Article 28. Very simple article, nothing to worry about. Freedom as to attendance at religious instruction or religious worship in certain educational institutions. Now, this is an extremely important article. We've done this sort of in a very interesting way when we've done education. Let us talk about this and I'll explain this to you very clearly. Okay, so see. We are now going to talk about the intersection of religion and education. Okay, we're going to talk about the intersection of religion and education and what kind of role does law play when religion and education intersect with each other. Now, basically, this is primarily governed by Article 28. Now, Article 28 basically says two things. The first thing that Article 28 says is the first part. This is not subsection A. This is just my way of dividing it. What it basically says is very simple. Religion cannot be taught at a state educational institution. Now, what does a state educational institution mean? It means any public school, any school under CBSE, any school under your respective state boards, and any school under ISC or ICSC as well, because it is the government who guarantees this. It's the government who recognizes it. So in any non-religious school, religion cannot be taught. Okay? And the other part of it is, the second part of it is that the government, the state, cannot interfere in the affairs of religious educational institutions. You can't tell a madrasa how to teach the Quran. You can't tell a Gurukul how to teach the Gita. You cannot tell a Sikh institution how to teach the Guru Granth Sahib, basically. But it's not that simple because there are going to be a lot of terms and conditions. Like for example, if you go for a sale, it will say buy two get two free on minimum purchase of 5,000 rupees. Similarly, this is not that simple. There are going to be certain terms and conditions that are going to be applied here. And these are very practical terms and conditions. Okay, so let's understand this. You would remember, especially in CBSE schools, Mahabharat and Ramayana used to be taught in school, right? Mahabharat and Ramayana used to be taught in schools. Now, Mahabharat and Ramayana are largely related to Hinduism, but Mahabharat and Ramayana were actually taught as a part of the Hindi curriculum as subjects of moral literary philosophy. Moral literary philosophy. No school in the history of this country can teach you Ramayana and Mahabharata and ask you a question on Hindutva or the Hindu religion. If you remember, everything that you studied about Ramayana and Mahabharata in school, the books that you read basically were historic in nature. That A happened and then B happened, what is your moral learning out of it? They never asked you questions on Hinduism. It is illegal. No school in this country can do so. It is that simple. So that is how Ramayana and Mahabharata was actually taught. It was taught as a part of your Hindi literature moral subject. It was not taught as an extension of a religious subject. Okay. Now let's come to the state interfering in religious educational affairs. Now, this relationship is regulated by a Supreme Court judgment called the TMA Foundation case, which basically tells you three things. You would remember filling this form in your 10th and 12th board exams. You would see that there are essentially three kinds of institutions, and we used to tick one out of the three. For example, first we would say either your institution is fully aided, or it would say that it is privately aided, or it would say it is unaided, right? These are basically the three kinds of institutions that exist. Now, if you are unaided, the government cannot interfere in your institution without your consent. Unless you ask the government, unless you request the government to assist you with certain religious practices, to assist you with certain things, the government can't. For example, in almost all the madrasas of UP, you have a parallel NCERT curriculum or an NIOS curriculum. It's because they requested the UP government to. Not that they were forced to do this. The Ministry of Human Resources runs a scheme called SPQEM, the scheme for providing quality education to madrasas. Now the madrasas can enroll and the government can set up an NIOS learning center in a madrasa so that the child can spend 6 hours a day in formal Islamic curriculum but can also attend open school and get proper formal education. Now, if you are partially funded, this is fully, if you are partially funded, then the government can only interfere in your affairs from a welfare point of view. But if you are fully funded by the government, then not only welfare, but also from an administrative point of view, in both of these cases, the government can easily interfere in your functioning. Now, I'll give you a simple example. Couple of examples actually. For example, you would have heard of a prestigious college in Delhi University called the St. Stephen's College, right? Now, a common mistake most people do is people think St. Stephen's College is an autonomous institution, or for that matter, St. Xavier's College. St. Xavier's is in Bombay is an autonomous institution. St. Stephen's is not. St. Stephen's is not an autonomous institution. It is a religious minority educational institution. It is completely funded by the government. It is a part of DU, which is a fully owned state university. So the government can interfere on administrative as well as welfare matters, which is why St. Stephen's has to abide by the same cutoff criteria for Delhi University, but they get the special treatment that they take interviews of candidates before they admit them into the undergraduate curriculum. Because Stephens is the only undergraduate college in the country, in Delhi University, who gets to take interviews for undergraduate students because they are a minority education institution. They have special powers to do so. Otherwise, they would have not been able to. Which is why Stephens also says, we are a part of DU, but we will never participate in the Delhi University student elections. Stephens never does that. Why? Because of special protections given under the religious minority educational setup. Right? This is also true for example, Jamia Millia Islamia, also true for Banaras Hindu University. So Hindus can study at Jamia, Muslims can study at Banaras Hindu University, Hindus can also study at Aligarh Muslim University. For example, take the case of Jamia. One of the most popular colleges of Jamia is the A.J. Kidwai Institute of Mass Communication. It is one of India's top mass communication colleges. Now, because Jamia is a fully funded government university, then the government can interfere on administration, can interfere on welfare. It has to just ensure that the identity of the institution is not compromised, which is why Stephens has a 50% reservation for Christians. Jamia has a 50% reservation for Muslims. The remainder 50%, anybody and everybody can participate. So the government says, okay, keep 50% of your seats for Muslims, the remainder 50% for everybody. Conduct a national entrance test for admission to A.J. Kidwai. Muslims can have a lower cutoff than non-Muslims. Similarly, Christians can have a lower cutoff than non-Christians. All of this happens because of Article 28, where the government cannot interfere in religious educational institutions. So you must understand there are two things. There is a religious educational institution which teaches you religion, like madrasa, and then there is a religious minority institution which does not teach you religion, but it is for people of a specific religion. That's the difference between a madrasa and a Jamia Millia. Madrasa is a religious educational institution. Jamia Millia is a religious minority institution. That's the basic difference between the two. Okay? And this is what Article 28 is. We're able to understand most parts of it. So we have now covered Article 25 to Article 28. I'll quickly run you through the articles. Extremely irrelevant. Freedom as to attendance and religious instruction, etc., etc. What are your basic provisions? No religious instruction shall be provided in any education institution wholly maintained out of state funds. We've covered this, that the religion cannot be taught in a state institution. Nothing in clause 1 will apply to an educational institution which is administered by the state but has been established under a trust which requires religious institution to be imparted. Matlab, if it is run by a state, if it is run, the trust is administered by the government, but it is funded by a trust where people come and contribute, then also a religious institution can be provided, but you cannot stop it. Then you have Article 28, Clause 3. It's very simple. No person attending this will be required, attending an education institution required by the state or receiving aid of the state, shall be required to take part in any instruction that may be imparted in such an institution, or to attend any religious worship that may be conducted in any premises attached to, unless the person is a minor and the guardian is given his institution. मतलब basically जब हम लोग को स्कूल में याद है वो असेंबली में प्रेयर कराते थे, ये शारदीय माँ, ये शारदीय माँ, आपको नहीं करना तो मत करो, आपको कोई कुछ नहीं बोल सकता. And if you're most of us are minors in schools, so unless the guardian has said नहीं करना चाहिए, till the time you can't force the child, because most of your prayers in schools are from the Hindu domination, are more from the Hindu faith. So if a person, for example, in Islam, you are not allowed to actually join your hands, but a lot of people in our schools tend to do that. Okay, so this is basically that. Nothing more is required. This is not technically a very important article as far as the exam is concerned. The basics are clear, that you cannot teach religion in a state, but if it is administered by the state, you can, but if and it's funded by the private trust. And third, you can't force a person in a state institution to perform anything religious. Okay, so these are the basic things. This is Article 25 to 28. 1 hour is up. I think you can take a 5-minute break, and then we will start at 9:06 a.m. Okay. All right. Let us continue with Articles 29 and 30. Quickly finish them up and then we'll move to 32. 31 we'll cover with the basic structure in the next part of class. Okay. Now we are done with this. Let us quickly look at Articles 29 and 30. Very small article, very simple article. I know there are a lot of discussions and judgments such as PA Inamdar and so on and so forth. By the powers vested in me by myself, I will declare them as completely irrelevant as far as the exam is concerned. Okay. Now we are going to move to cultural and educational rights. So let's understand what it is that we are talking about. What part of culture and educational rights do we have to refer to? Okay. So let's look at it, let's understand it, and let's figure this out. So, protection of interests of minorities, Article 29, that is the title of the clause. Let us start and let's get this part right. Okay. All right. So, you will often hear of the word minorities. Now, you must understand that the word minorities is not defined anywhere in the Constitution or, in fact, under any law. Okay. It's not defined anywhere in the Constitution and is also not mentioned anywhere in the law, which basically means that the word minority is a very relative concept in a given area, in a given space, in a given geographical context, right? Minorities, therefore, are people who are in a lesser population there. For example, Tamil speaking people are a minority in Delhi, and Hindi speaking people are a minority in Tamil, in Tamil Nadu. That's basically what a minority means, right? In a geographical area, because of your language, your culture, your religion, if you're in a lesser number, then you are a minority. That is a simple explanation to this. Now let us look at Article 29, Clause 1. Article 29, Clause 1 only applies to citizens, and Article 29 largely applies to citizens only. So, any section of citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. Now, how do you conserve it is mentioned under Article 30. Article 29, Clause 1 simply establishes the right of minorities, which is a relative concept, to protect what makes them a minority. It could be a language, it could be script, it could be culture, it could be anything which is an identifier. Okay? And no citizen shall be denied admission into an educational institution maintained by the state or receiving aid out of state funds on the grounds only of religion, race, caste, language, or any of them. What is very interesting to notice that this is very similar to previous fundamental rights pertaining to discrimination. That you cannot discriminate against a person based on the CRRSP or the DRCRRSP principle. But here you very clearly mention that no citizen can be denied education into an educational institution either owned by the state or funded by the state on the basis only of religion, race, caste, language, or any of them. This is also why, for example, Hindus can take admission in Jamia and Muslims can take admission in Banaras Hindu University. Now, what does the whole only concept mean? We've discussed this before. So, only on religion, race, caste, language means either of these, a combination of these. But if there is something else that you want to add, you can. For example, some local reservation for the people of that state. That is perfectly okay. That is perfectly allowed. And that is something that will not be questioned in a court of law. This is a simple article. Nothing to worry about. Now we look at Article 30. Alright. Now we look at Article 30. See, this is what Article 30 says. The right of minorities to establish and administer educational institutions. Now, this does not only include formal institutions or degree institutions, it could be education of any kind. So, it is the right of minorities to establish and administer educational institutions, Article 30, Clause 1. All minorities, whether based on religion or language. Here they have clearly mentioned the kind of minorities that we are referring to. There can be more, but religious or linguistic minorities have the right to establish and administer educational institutions of their choice. This is exactly what is written in Article 30, Clause 1. Right? Now, all of them. Now, it could be beyond religious or educational minority also. That's also not a problem, but it specifies religious or linguistic minority. Then, it was later on added, you don't have to worry about the amendment per se, that in making any law providing for compulsory acquisition of any property of an education institution or administered by a minority, the state shall ensure the amount fixed or determined is such that would not restrict or abrogate the right guaranteed under that law. Now, what is this? Why is this important? This actually becomes very important in the context of the Keswananda Bharti case, because it was basically religious property which was acquired by the government. The idea here is that if the government is acquiring the property which is originally earmarked for an educational institution administered by a minority, that kind of a acquisition, that kind of a government ownership of property or transfer of property to the government should not restrict the right, should not stop people, or should not in any way hinder their right to be able to conserve their minority status or to conserve what defines them to be a minority. And the second provision is the state shall not, in granting an aid or any amount of support, discriminate against any educational institution on the ground that it is that the management of the minority based on religion or language is the one running it. So you will not discriminate that अरे नहीं ये इनके ये हिंदू मैनेजमेंट बोर्ड है, ये क्रिश्चियन मैनेजमेंट बोर्ड है, ये बुद्धिस्ट मैनेजमेंट बोर्ड है, तो हम इनको पैसा नहीं देंगे. ऐसा नहीं है. You cannot discriminate on the basis of who's running that board. That is it. This is all that Article 29 and 30 really talk about. And as I was telling you, this Article 30 Clause 1, we're talking about the 44th Amendment, which is essentially the post-Keswananda Bharti Amendment. So actually Article 30 Clause 1A, Article 30 Clause 1A is essentially a governmental response to the Keswananda Bharti judgment, which we will discuss, in fact, in just some time from now. So this is what it is. This is what Article 30 Clause 1 is, and this is all you need to know from the basics of it. Okay? Clear? So this is 29 and 30. Takes care of your cultural and educational rights. There is not much to explain here. There is nothing much that you have to really worry about or get into. It is extremely irrelevant. There has not been a single question from here across the board ever in the pre or the means, because these are ancillary rights. They're not that important when we compare it to the rest, and there have been no major developments significant enough under 29 and 30 for you and I to really be worried about. Okay. Now, with respect to 31, we will cover this in the context of basic structure, so don't worry about it. We'll come to that later. We should now be looking at what are called writs or Article 32. Now, we'll start with Article 32, 31, and we'll cover that later. So don't worry about it. We're going to now look at Article 32, extremely important, right? And I will do this in the right context, in the right explanation of this. Okay, so let's start. We are now going to be looking at the right to constitutional remedies. Sorry, as you would know, uh, Anishant, I'll come back to you. Students are late. Today's the mains exam, and I just got a call from somebody in panic. Sir, what can we do? We are on our way. We haven't reached the exam center yet, and it's already 8:50 a.m. Let's hope we're able to resolve it. Seems rather unlikely. Okay, now let us start and let us try and finish this up as early as possible. Okay, so let's try. We are going to look at Article 32, which is nothing but the right to constitutional remedies. The right to constitutional remedies. Okay? Now, what is very interesting to note here is that India is one of those rare constitutions in the world where the mechanism to have your fundamental rights enforced, or the mechanism of grievance when your fundamental right has been violated, that mechanism itself is a fundamental right. Almost no other country in the world provides for Article 32 or provides for right to constitutional remedies as a fundamental right like India does. And Article 32 must also be done in comparison to Article 226, because the remedies which are available under 226 are actually quite similar. Alright. Now, the basic idea is that if Articles 14 to Articles 30 are your bullets, These are the fundamental rights that are available to you. Article 32 is the gun through which you fire the bullet, and so is also Article 226. Now, in our original discussions in our first taught classes on fundamental rights, I had explained to you the concept of enforcement, right? Now, if a fundamental right is violated, one of the special things about fundamental rights is that you can directly approach the Supreme Court, and the Supreme Court is empowered to hear your case under Article 32. It is under 32 that you can approach the Supreme Court. Now, you also can approach the high courts as well. And this is under Article 226. We're also aware, we've done this before. If it is a legal right violation, or in common parlance, a constitutional right violation, then you can only and only go to the High Court directly as the first court. From here, you can go and appeal, that is okay. But the first court that you can go to is the High Court. This is why we often say that the High Courts have larger powers than the Supreme Court, because they can get to decide on a wider range of rights as opposed to the Supreme Court. At a wider range of rights as opposed to the Supreme Court. We know this is why it is. Now, once we understand this, let's understand what is it that we are talking about. That becomes the important part. See, what we're saying is that a simple example, and let's understand this. Let us say there is a person A. This person A, like me, has a beard and wears glasses, and this person A, for example, has to board the Delhi metro. Okay. Now we know Delhi Metro is owned by the Delhi Metro Rail Corporation, and this qualifies as an instrument of the state under Article 12. Now, when the person wanted to board the Delhi Metro, one of the officials at the metro station denied the person access to Delhi Metro. Denied the person access to Delhi Metro. Okay? Now, as a result of this, A's fundamental rights have been violated, right? Now, this denial could be because there could be a law that says so. So, Article 14 may be violated. Accessing a public space is a problem. 15 might be violated. A had to go to work. Now, A can't go to work. A might be fired because of this. So, Article 21 may also be violated, right? A might have to go and meet some people, may have an organization, may have to go and work somewhere. So, indirectly, Article 19 would have also been violated. So, if so many fundamental rights have been violated, then A has a choice to make. A can go to the Supreme Court or the High Court directly, right? And file a petition. Okay? File a petition. A petition under 32 or 226. Under 32, directly to the Supreme Court. Under 226, directly to the High Court. Okay? Now, a court is not somewhere you go and rant. You go to court for a very, very specific reason. You go to court because you want to get some kind of relief. You want to court because you're looking for some form of resolution, some form of solution to who you are and what you are. Correct? So what basically happens here is that when you go to court, this is extremely important. You don't go to court and say मेरे साथ बहुत बुरा हुआ, आओ चलो चर्चा करते. नहीं. You go to court seeking what is called relief, right? Now in this scenario, you will go to the Supreme Court or the High Court. Let us say you decide to go to the Supreme Court, and you will specifically ask the Supreme Court to issue an order to the Delhi Metro, to the Delhi Metro Rail Corporation, allowing A to board the Delhi Metro. Allowing A to board the Delhi Metro. Okay? Allowing A to board the Delhi Metro. Understood this? So, the order of the court to enforce a fundamental right, this is called a writ. Okay? So, what is meant by a writ? A writ is nothing but a specific order issued either by the Supreme Court or the High Court to uphold a fundamental right or a legal right. This is what is meant by writ. W-R-I-T. This is what is meant by writ. Okay. Now comes the advanced part. Let's understand the advanced meaning of writs. Let's understand certain applications of this. So basically, let's look at, say, 13 clause 2 for that matter, or anything. Basically, there is something called Article 13 clause 2. Article 13 clause 2 we will refer to now in about half an hour or so, that no law can violate a fundamental right. This is the other thing which makes fundamental rights oh so special, that no law can violate a fundamental right. Now, this law can be a law passed by the center, and this can also be a law passed by the states. UP, MP, Maharashtra, Tamil Nadu, Karnataka, Bihar, etc. Right? Now, let us say, for example, and this law could be an entire law, or this could be a specific section or a specific provision of a specific law, section 42, section 45, section 50, so on and so forth. Okay? Now, if, for example, a law has been violating fundamental rights, you can go to the Supreme Court also, you can go to the High Court also, because both of them have the right to examine the constitutionality of it. Because if it's violating a fundamental right, you can go to both of the courts. You can easily go to both of the courts. Yes, which means both and this is the most important part, both the Supreme Court and the High Courts have the powers to determine the constitutional validity of any law. You can challenge a law made by the parliament in a high court also. You can challenge a law made by the state legislature in the respective high court also. So please understand this. How does it work? So in the Supreme Court, you can challenge a law made by the center, and you can challenge the law made by any state legislature as well. Okay? In the High Court, you can challenge a law made by the Parliament or the Centre, or you can challenge a law made by the legislature of that particular state, of the same state as that of the High Court. As that of the High Court. Okay? So, for example, let us take some prominent examples. You may have heard of something called Section 377 of the Indian Penal Code. Now, this provision talks about unnatural sex and therefore indirectly refers to homosexuality. Okay? This provision was actually first challenged in the Delhi High Court in the Nas Foundation case. And this IPC is a central law, right? It's a central law. Now, let's understand this as clearly as we can. Okay? Now, the Delhi High Court originally, many years ago, had actually declared IPC section 377 as unconstitutional. Then the case went on appeal to the Supreme Court, got reversed back to the Delhi High Court, and then the Delhi High Court again pronounced it as constitutional. But for about 3 to 4 years, homosexuality in the mid 2000s was perfectly legal, but only in Delhi because the Delhi High Court had said so. Later on, Section 377 was challenged at the Supreme Court in the Navtej Singh Johar judgment, and it is a center or a parliamentary law. And in the Navtej Singh Johar case, the Supreme Court declared Section 377 to be okay, but homosexuality will no longer be considered a part of Section 377. So it will not interpret to mean Section 377. And as a result of which, the Supreme Court decriminalized homosexuality. Okay? Supreme Court declared homosexuality as unconstitutional or criminalized, as declared homosexuality as, or criminalization of homosexuality as unconstitutional, and therefore decriminalized homosexuality. Now, this Navtej Singh Johar judgment would be applicable to the entire territory of India, whereas this Delhi High Court judgment for those 2-3 years would have only and only been applicable to the state of Delhi. Okay, so this is basically what it is, the applicability of it. So if in the prelims you get an option, can the constitutional validity of a law be challenged in the High Court? Absolutely. Can it be challenged in the Supreme Court? Absolutely. No problem at all. Okay, clear on this? Okay, you can take about 1 minute to take a note of this, and then I'll show you the previous slide also. Okay, got it? Done? We'll look at the previous slide as well. So, this is the slide, and through this slide, I'll explain to you what jurisdiction and locus standi and all of those things mean. Okay? Now, you see, there are two words that we look at. The first word that we often refer to is called jurisdiction. Now, jurisdiction simply means the power or the capacity, the power or the capacity of a court to hear you, to hear a case. Okay? And locus standi is again a Latin term which means the capacity of the person, of a person to approach a court. Now let's apply both of these principles here. Now, the jurisdiction of an issue here is that you can go to the Supreme Court or you can go to the High Court, only and only the Supreme Court and the High Court of the state of Delhi, the Delhi High Court, will have the powers to hear this matter. Okay? If you go to High Court of Karnataka for this, they will not have the powers to hear the matter. If you go to District Court of Delhi for this, they will not have the powers. They don't have the jurisdiction to. Right? Second is, this is something which has personally happened to A. Right? Now, this means A can approach the court. Right? A can approach the court. Or anybody who represents a similar class of people can approach the court through something called a PIL, a public interest litigation, wherein your locus standi rules are relaxed. So here A only can. For example, let us say there is a property dispute A versus B. You will go to a civil court, but only A and B can go to a civil court. C, who is a neighbor of A or B, cannot show up to the court and say, see, they are fighting, I'm feeling bad. Only A and B can, right? So C does not have the locus to go to a court. Here, A has the locus to go to a court, and that's largely why something like this happens in the first place. All right? Okay? Nishant, with respect to your question, the reason we wanted to mention this is because in the aftermath of the partition, we were going to be an extremely reliant country. We were going to be a country which was very diverse in forms of culture, costume, and language. So that is why. Okay, understood this? Are we fine with this? Okay, all right. Good. So, we figured out what is meant by a writ, what is meant by the court that we are going to. Now we are going to simply look at the kinds of writs. Then I'll read the article for you, so it will be easy. Okay. Now let us look at understanding the types of writs. All right. So let's start. The types of writs. So let's understood. Okay, let's understand. Guys, I hope the video and audio quality is okay. I hope you're able to see what is being written on the board clearly. I hope that is the case. I hope that is fine. Yes? If it is, please let me know. Right? Because I am teaching from home today. So this is all set up at home. So everything that you see, this is happening from home, right? Which is also why 8 o'clock sharp we were able to start. All right. All okay, Varun? Thank you. ठीक है, perfect. चलिए. All right. Now let's look at types of writs. Now, the names of these writs, as we would know them, are actually in Latin. Okay. Now, in the mains, we've never had questions on this, and the problem here is absolutely clear, right? Perfect. All well. Okay. Good. Now, it's the same setup. It's just there's a TV now. And this is a big TV, so I'm very happy. I can play video games on it now. All right. Okay. Now, in the mains exam, I have never seen a question on the description of writs. In the prelims also, I have not particularly seen a question on the details of these writs. Now you must understand why. Because the procedural details of these writs is beyond the constitution. You must understand this. The procedural details of these are actually not mentioned in the constitution. They are either run through Supreme Court judgments or they are run through what are called Supreme Court guidelines and directions, right? That's where you essentially get to do this. Like, for example, so there is a book which I often refer. This is a book not for you guys, but there's a book called Supreme Court Guidelines and Directions. It is this book that will usually contain details of what kind of procedures to follow for writs and so on and so forth. Okay, so there are several such books, and these are essentially things that I would read for class and stuff like that. But in the mains exam or even in the pre, this is asked in a very, very limited perspective. You should just know what they are, what their purposes are, and certain key details out of it. Okay, now there are basically 5 kinds of writs that we refer to, and these are the 5 kinds of writs that are important. Okay, so let's look at it. So the first is habeas corpus. The second is mandamus. The second is mandamus. The third is prohibition. The fourth is certiorari. The fifth is quo warranto. Now, when we study this, you will only study it in the details that I teach you. Anything beyond this is not going to be important as far as the exam is concerned. Okay? Now, habeas corpus, as we would understand habeas corpus to be, habeas corpus is a writ which is available against primarily illegal detention. Is available primarily against illegal detention, because illegal detention also affects the movement of the person who has been detained, and anybody can illegally detain anybody. So this detention can be by the state and can also be a private individual as well. Okay? And that is why habeas corpus is the only writ which can be issued both against state and private, because movement as a fundamental right is enforceable against state and private. Okay, so for example, if this was a physical classroom and I had locked you up in the classroom and I'm obviously not the state, I'm also not any agent of the state or the government of the state or anything of that sort, then obviously a writ of habeas corpus can be filed against me in the Supreme Court or the High Court. Now, the trick question is, if you are detained, then how will you go to court? You are locked up in a classroom. So, a friend of yours, a relative of yours, a cousin of yours, a parent of yours, on your behalf can go to the court. That is why, in the writs of habeas corpus, you do not have strict locus standi principles. You do not have strict locus standi principles. That's the basic difference. Okay, so these are the only things that you have to know. Historically, this writ of habeas corpus was massively in news during the emergency because there was a law called the Maintenance of Internal Securities Act, and this law allowed the government to detain people without trial, without taking them to a court or a magistrate, if they were a threat to national security. And several leaders, such as Vajpayee and Advani, were all taken to court, were all put behind bars under the Maintenance of Internal Securities Act, which continued. This is nothing, the Maintenance of Internal Security Act is actually nothing but a preventive detention law of that time. It still continues to be in operation. Today, the most modern version of it is the Unlawful Activities Prevention Act. Okay, understood this. Now, once we are clear with this, you must understand this in a greater amount of detail. There was a very old case during the emergency, and the Supreme Court was also severely criticized for it because of the judgment that the Supreme Court had given, largely because the Supreme Court was possibly under the influence of the government of that time during the emergency, as the Supreme Court, in a few of its earlier judgments, has tried to give very pro-government decisions in the times to come. So this case was ADM Jabalpur versus Sivakant Shukla. In this, the detention of several political detainees were challenged in the court, and the court, in one of its darkest decisions, in one of its most shameful decisions, decided that a habeas corpus cannot be granted during the time of an emergency. And of course, this judgment was criticized, and later this judgment was reversed also. So today, a habeas corpus can be granted at any given point of time for any circumstances, right? Now, because locus standi principles are not very strict, so yes, you can file a PIL on anything, by the way. So it's not just about, a PIL can be filed seeking habeas corpus. That's okay. That's not a problem at all, right? Okay, so that's the case. Now, mandamus is a very specific writ. How Shakespeare says to be or not to be, the basic understanding of mandamus is to do or not to do. To do or not to do. This is usually issued against the executive. In rare cases, you may want to, very rarely do writs get issued against the legislature, because that would be a direct confrontation of separation of powers, but it is usually used against the executive, all in any forms of it, either asking the executive to do something or specifically prohibiting them from doing something. And I'll give you a real example that concerns you. So last year, when the mains exam was happening, not the 2021 exam, the 2020 exam, which was happening last year, several students were not able to get their university mark sheets on time because of the pandemic. And the pandemic had ensured that the universities were not able to display and relay the results in time. Now, these fantastically brilliant students who were able to clear the prelims in the first attempt were now due to write the mains exam. Now, in the mains exam, before writing of the mains exam, there is a detailed application form part 1 which you have to fill. Part 2 you have to fill after you write the mains exam and before you appear for the interview. Now, in part 1, you have to enclose your university transcripts and your degrees. Unfortunately, what had happened was that their university transcripts and degrees were not available. They wrote to the UPSC, and the UPSC, of course, um, uh, UPSC, of course, said that okay, give us in writing, and we will ensure that you're able to write the mains exam. Give us in writing that your university exams, your university results are delayed. They were allowed to write the mains exam. What happened after that was a gross violation of morality and justice. The UPSC sent a letter to all of these candidates saying that your candidature for this exam now stands cancelled and you shall no longer be allowed or permitted to appear for the interview. This is after the UPSC had taken and allowed them to write the mains exam. Uh, Thankfully, these students kept in touch and they approached, and I represented them entirely free of cost because I don't take money from students for legal representations. We went to the Supreme Court, we filed a petition. Khanwalkar was one of the judges. It was a double bench judgment, a double bench setup, and we basically asked for a writ of mandamus to be issued against the UPSC and the DOPT, allowing these students who have qualified the mains to appear for the interview, as it was not their fault that the university results were delayed, it was the pandemic's fault. All right, it was not their fault, but it was the pandemic's fault. All right, now as a result of this, we were able to then ensure that these students appeared. And one of the greatest moments of my life is that out of the 14 students whose candidatures were cancelled, there were about 7 who qualified the mains, 6 who qualified the mains, and 3 to 4 actually cleared the mains exam. Somebody getting into the police services, revenue, so on and so forth. None of them made it to the IS in the first attempt, the ones that we were talking about, but they got through the exam, and that is good enough, I think, because it gives you an incredible moral boost as far as the exam is concerned. All right, so that is something that we must know. That is something that we must always remember. We must always help as much as we can. So this is what is called a writ of mandamus. Right now, in this, because it is a specific action, you would usually see a stronger application of the principles of locus standi. Now, what I've written here, which I think is gotten covered by the logo, is no strict locus standi principles, and habeas corpus is available, is the only writ which is available against the state as well as the private as well. Okay, now I'll keep that in mind. Now, prohibition and certiorari have to be studied together because they're related to each other, and they have a judicial component to this. They have a judicial component to this, and they are applicable to anybody, any body, any institution which is performing a judicial or a quasi judicial function, like a semi judicial function, even a commission, a tribunal, a court, it doesn't matter. Anyone and everyone would be okay, would be applicable in this regard. Okay, understood this? So, prohibition and certiorari are primarily judicial related writs. They're writs pertaining to the judiciary per se. Okay, so let's understand what they are and let's try and figure out what they mean. So they are applicable, as I was telling you, to any body which is performing a judicial function or a quasi judicial function. Either a judicial function or a quasi judicial function, and it could be anybody, literally anybody on the face of the earth. Okay, on the of course on in India. Now the difference is prohibition means very simply you have gone to the wrong court, which means wrong jurisdiction, and the case is pending. The case is currently going on, but it is going on in the wrong court. The court did not have the power to entertain the case. And certiorari, on the other hand, is no doubt you went to the wrong court and the case has been decided. A judgment has been given by the court. Or you went to the right court, but the court did not have the power to give the kind of judgment, the kind of punishment it did. मतलब तुम सिविल कोर्ट में गए प्रॉपर्टी डिस्प्यूट के लिए, उससे तुमको डेथ पेनल्टी दे दी, ये नहीं कर सकते. ठीक है. And the case has been decided, the wrong punishments have been given. Okay, wrong punishments have been given. Are we okay with this? Right? So these are usually referred to, and usually either executive, because tribunals also comprise of the executive, and of course judicial bodies. So prohibition and certiorari is used in that front. Okay. In both of these cases, so in prohibition, the case is pending, you might still be in jail. So locus standi does not strictly apply. Here also, in most cases, locus standi does not strictly apply. It depends from a case to case basis. Okay, it depends from a case to case basis. Are we clear with this? Do we understand this? Yes? Now we look at quo warranto. Now let's understand what quo warranto means. Okay, quo warranto. Quo warranto refers to under what authority. That's the literal meaning of this. And it is always, in most cases, applicable only and only to the executive. Right? Now, for example, let us say you don't have an arrest warrant and you're arresting for a crime that requires an arrest warrant. Quo warranto. Search and seizure without a warrant for a crime that requires a warrant. For an offense that requires a warrant. Quo warranto. If a brown traffic police cop asks you for anything apart from your license and insurance, it's a quo warranto violation. Only white traffic police cops can ask you questions on license, PUC, insurance, etc., etc. Okay, but brown traffic police cop, as in cops with the brown uniform, they are the only ones who can ask you for. They can only ask you for license and insurance. It's the white uniform cops that can ask you for any and every related information with respect to your cars. Right? So brown can ask for your license, insurance, and your car registration. White traffic police cops can ask for PUC, can ask for dating of the car, etc., etc., etc. Clear? So these are the kind of writs that are used. Anything more than this, very honestly, is not in your syllabus. I would love to get into a lot of technicality here and teach you some complicated discussions here. But none of these discussions are asked because how they are used is actually not in the constitution. It is a matter of procedure. It is procedural law. And procedural law is actually not in your syllabus. So if you read anything which teaches you technical details beyond this, you're actually reading something which is not in your syllabus. So if you actually go through Article 32, you'll understand what it is that we are largely referring to. Okay. So see. Article 32 is referring to enforcement of rights under this part. The right to move the Supreme Court by appropriate proceedings for enforcement of these rights, as we said, will have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of rights conferred by this right. Okay. Now, without prejudice to powers conferred on the Supreme Court by this, the Parliament by law can empower any other court within the local limits of its jurisdiction or any of the powers exercisable by the Supreme Court under clause 2. Matlab, Article 32 clause 3 says, if the Parliament wants, you can also ensure that any other court which the Parliament has the rights to make laws over, right? 1 second please, sir. Under Article 32 clause 3, the Parliament, without compromising the powers of the Supreme Court, can empower any other court that it has the powers to make laws on. It has the powers to regulate. And within the limits, of course, its jurisdiction, that they can also issue similar rights. Of course, today, these rights are extendable under 226 to the High Court as well. But apart from that, no other court in India has been given this power. Okay. Now, Article 32 clause 4 says, the right guaranteed by this article shall not be suspended as otherwise provided in the Constitution. And this is largely referring to provisions with respect to emergency. So when we cover emergency, I will explain this to you in detail, wherein I will tell you that in a certain type of emergency, during the period of that emergency, for example, if the emergency is for 1 month, if your fundamental right is violated, you cannot go to, for 1 month if your fundamental right is violated, you cannot go to the court for that 1 month. But after the emergency is over, you can go to the Supreme Court and say that within this 1 month, my XYZ fundamental rights were violated. So, technically, you can stop a person from reaching the court during an emergency, but you cannot permanently stop this right altogether. Okay, so we will cover this whenever the time is right as far as the emergency is concerned. Okay, so that is that. This is Article 32. Then Articles 32A, 33, 34, 35. These are irrelevant. We will cover them after basic structure. So don't worry about it. Now the most important part is over. 34 is basically marital law, and 35 is of course laws with respect to influence of marital law and other martial law, sorry, not marital law, of other fundamental rights. Okay, we'll cover them. They're not important at all. They've never been, they're not even relevant enough to be discussed, but I will still discuss them because they're in the text of the Constitution. Right? Now, nothing beyond this, as the cursory part is important as far as your exam is concerned. I can see some questions. So, Richa, the Supreme Court or the High Court will decide, right? So Vaibhav is asking, in the future, no, because the Parliament has the powers to regulate the judiciary anyways. Vaibhav, we haven't studied the Supreme Court yet, but you will understand this, that the Parliament has the powers to regulate the powers of the Supreme Court in the first place. Independence of judiciary means the independence in the appointment and the removal of the judiciary. But that does not mean that the judiciary cannot be regulated at all as an entity by the government. Okay, so that is something that we have to know under all circumstances. Okay, clear on this? All right. So we are done with this. Now tomorrow we are going to have a longer class for about 3 hours. In the first 1.5 hours, we will discuss broadly. We will discuss basic structure, harmonious construction, etc., etc. And in the last 1.5 hours, we will discuss the rights issues with respect to fundamental rights. So we will be able to completely finish theme number 3 by the weekend, and then we can start with Parliament and President and so on and so forth from Monday itself. By next week, not only will be done with the executive, we will also be done with the legislature, and then we'll move to center, state, and judiciaries. We're perfectly on track. 2 weeks, your polity syllabus should be done. Okay, we'll cover this, Lomarshi, don't worry, when we cover homosexuality tomorrow. Okay, of course, we will discuss Jayaprakash means questions. Why will I not discuss them? I haven't even come to the issues yet. Okay, so thank you. Thank you. High courts can also issue. I just explained that, Saurabh. No, Kumar, we can't say that because Article 26 already exists in the Constitution. भाई गुड मॉर्निंग सर. क्लास हो गई सर. अब क्या करना है, क्या बटन दबाना है? अच्छा, तो रिकॉर्डिंग बंद कर दूं? ओके, कर दी भाई. यस सर. भाई ये तो बहुत सही हुआ आज.